All right, so I'm going to turn it over to the judges now.
Thank you very much. My name is Richard Blighter. I'm the director of the Law Library and professor of law at the University of Nebraska School of Law here in Lincoln, Nebraska. I've been judging state competitions for about 15 years, and this is my first time at the Nationals. And I'm very happy to be here and happy and anxious to hear what you guys have to say. My colleagues are
Candida Steele. I'm retired as a judge on the U.S. Civilian Board of Contract Appeals. I handled federal government contract disputes around the country, civilian cases, not military. And I've been with this program for 20 years and think it's pretty fabulous. Welcome.
All right, good morning. It's still morning here. I'm in Colorado Springs, Colorado at the Air Force Academy. I'm Lieutenant Colonel Kurt Mabus. I'm a JAG with the Air Force and an alum of the program from your southern neighbor down in Indiana.
very good. Can you introduce yourselves, students?
Thank you for allowing us to testify before you today. We are a unit composed of juniors and sophomores from East Grand Rapids High School. I am Ella Drojewski.
I'm Jack Lato.
I'm Lauren Bentley. We are coached by Adam Horos and Benjamin Langholtz, and we are Unit 5.
Very good. It sounds like we're all in the same place or in the right place. I hope this doesn't come as any surprise to you, but we're going to discuss question 2, Unit 5. Good. No surprise. So let me read it for you. A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no government should refuse or rest on inference. Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? And what are the differences between positive and negative rights, and which are more important to the preservation of liberty? All yours.
John F. Kennedy remarked, "The Bill of Rights is the guardian of our security as well as our liberty, as it safeguards the citizenry from an overbearing government." In colonial times, the government valued their own justice system over the privacy and protection granted to their citizens. In the case of Wilkes v. Wood, general warrants were applied in order to achieve this large government overstep. In doing so, the rights of Englishmen and the principles they emphasized were left up to the interpretation of the government. Without a recognized Bill of Rights, the colonial citizens were left vulnerable to a limitless government, thereby justifying Jefferson's claim that a Bill of Rights is what the people are entitled to against every government on earth.
In order to protect fundamental liberties and not embarrass the future, our founders created a clear and deliberate Bill of Rights that enumerates the rights our country values. This decision emulates the ideas established in the Old English case of Entick v. Carrington. If it is law, it will be found in our books. If it is not to be found there, it is not law. In order to ensure that the rights we value are protected, it is best that they're clearly stated and not rely on inference.
Yet, Madison was keenly aware it was impossible to enumerate every right of the people, and as our country has evolved, substantive rights and penumbras have emerged. The 9th Amendment, coupled with the 14th Amendment, allows for protections that are not specified explicitly in the Bill of Rights, such as privacy or marriage. In this sense, we disagree with Thomas Jefferson because fundamental protections can partially be derived from inference.
The National Bill of Rights holds many advantages for the consistency of government throughout our nation. One advantage is that it creates a minimal floor of protections, promoting unity and cohesion. Prior to incorporation, states didn't have to adhere to the guidelines set on a federal level. Beginning with CBQ Railroad v. Chicago and Gitlow v. New York, the court began selectively incorporating the Bill of Rights to build a more solidified set of regulations that protect the people. Therefore, the National Bill of Rights is imperative in establishing benchmark jurisdiction in order to protect specific individual freedoms, regardless of which state one resides in.
The state's Bill of Rights, although not consistent throughout our nation, come with their own set of advantages. First, state bills of rights are easier to amend, and 26 states have ballot initiatives, enabling them to be more reactive to the people. Furthermore, states act as laboratories of democracy through new policies. In 2004, Massachusetts became the first state to legalize same-sex marriage, which culminated in the 2015 case of Obergefell v. Hodges, legalizing same-sex marriage on a federal level. Finally, state constitutions are bastions for positive rights, such as education, worker protections, and environmental rights.
Positive rights are those which protect people from something other than the government. State constitutions oftentimes behave as our laboratories of democracy and a prime breeding ground for new governmental actions. Therefore, some of our most prominent positive protections lie within the text of our state constitutions. Rights that are oftentimes overlooked, but a significant positive protection, are environmental rights. States such as New Mexico and Montana include provisions that state, "It shall be policy to conserve and protect our natural resources." By offering added protections for these areas, it does not defend the populace from the government itself, but allows added protections for the citizenry.
As distinguished by political philosopher Isaiah Berlin, negative liberty is concerned with the freedom to pursue one's interests according to one's own free will. These rights are essential in carrying out the originally intended purpose of the Bill of Rights, as defined by James Madison, to protect against abuse of the powers of the general government. Since negative rights limit infringement of our natural rights, they are therefore more important to the preservation of liberty. By creating a nation with a Bill of Rights that protects individual freedoms to the highest regard, our nation has granted its citizens what the people are entitled to against every government on earth. Thank you. We are now ready for your questions.
Thank you very much. Let's start out with what circumstances, if any, can cause a person to lose rights found in the Bill of Rights?
Our Bill of Rights is put in place in order to protect the people, but those rights are not always guaranteed. For example, many times in our nation's history, example, free exercise. In certain cases, as example, Employment Division v. Smith, in order for certain rights to be protected, it must be paired with another right, as alluded to in the two nexus test.
Also, in the case of Brandenburg v. Ohio, the court ruled that freedom of speech can be limited if it incites imminent lawless action. So this is one example of where the freedom of speech is not finite.
Going off of what my colleague said, another circumstance in which your rights can be taken away would be by the time, place, and manner restrictions on free speech established in Keegan v. Cox v. New Hampshire.
So what do you think, what do you think's been left out of the Bill of Rights?
So many of the substantive rights that our court has given us, such as the right to marriage in the case of Obergefell v. Hodges and the right to raise your child as you see fit in the case of Pierce versus Society of Sisters, have not been firmly been a part of the Bill of Rights.
Going off my colleague, the right to privacy is alluded to as a penumbra right in our Constitution, and it is alluded to through the 1st, 3rd, 4th, 5th, 9th, and 14th Amendments, but is nowhere officially a constitutional amendment in our Bill of Rights. And I believe this has been left out because it is a very important right as recognized by our Supreme Court repeatedly through cases like Olmstead v. US and Katz v. US.
I believe something also left out of the Bill of Rights would be a specific amendment regarding voting, stating that every American has the right to vote. And I think that that could potentially settle some of the debates against the legitimate voting system that we've seen in our recent elections.
Now, how do I know when something becomes a right rather than a good for society to have? For example, the three things you mentioned, marriage, privacy, and voting, the founding fathers didn't bother to call these rights, and now you're calling these a right.
I personally think as society shifts, so do the rights that we need to guarantee. I think in today's day and age, we live in a very hyper-polarized society. So lots of the rights that we hold value are now put up to question due to our two-party system and this idea that our representatives sometimes aren't in favor of the people, but rather their parties. And so in that situation, things like a right to vote have become more important in order to adjust to those issues we face.
Also, in finding rights, we can often refer back to John Locke's theory of natural theory of rights, which regards our rights that we would have if there is no government set up, such as freedom of speech.
Okay, let's explore this a little bit further. There are different types of rights and different mechanisms for revealing them. Do you see a difference between the rights listed in the Bill of Rights, amendments to the Bill of Rights, and court recognized rights? Are there differences between those three types?
The main differences between those three types of rights are the ways that they are derived. So we have our substantive rights, which are often found through things like due process and things from like our 14th Amendment. And then you have our penumbra rights, which are often are products of our court system. And I think it is important to have multiple different ways to derive rights, because things like the Supreme Court allow the people themselves to take the Bill of Rights as a rallying point and bring it to those 9 justices to truly bring rights to the public eye that they believe are necessary.
I would say that one similarity is that the First Amendment really protects minorities, and you can see through the 15th, 19th, 24th, and 26th suffrage amendments that really helps to protect the minorities in our nation, and it furthers the intent of the Bill of Rights.
Okay. So rights were first recognized, the rights that were recognized under substantive due process, are they positive or negative?
I would argue that positive rights are those which the government grants to the people. And I believe things like equality, which are often what are discovered through the 14th Amendment. For example, in cases like Yickwo v. Hopkins, equality is something that I believe as people we should grant to ourselves and to our neighbors in a positive and functioning society. So therefore, I would argue that the right to equality, and oftentimes derived through due process, is a negative right, because that is something that the people should be entitled to against every government on earth, as Thomas Jefferson once said.
I believe that many of the substantive rights are negative liberties or negative rights because, for example, in the right to marriage is something that the government can't take away from you, no matter what. And this is similar with the right to raise your child as you see fit, and Pierce v. Society Sisters cannot be taken away, so they'd be negative liberties.
Also, I believe some things, such as due process in general, can be more negative in theory. However, in execution can be more positive, because due process is supposed to provide us with liberties. However, it is an actual process that the government does have to give you in order to take away our liberties.
You mentioned the states, and especially the state Bill of Rights, are bastions for democracy. Do you support Georgia's updating their voting rights, or Florida's anti-protest laws? Do you think that the states, as the laboratories of democracy, have that authority?
I would argue that states do have their police powers as offered in the case of Mugler v. Kansas. And in the concept of federalism, we do offer the states a lot of power as they are closer to the people. But that power doesn't always mean that they will do good with it or necessarily what the people will want. I mean, we talk about them as laboratories of democracy, but in a sense, in a laboratory, things can go well and things can also go badly. And so I think it is important that we have those places in check, because if they do make a mistake, we know not to enforce it on the federal level.
Well, who is enforcing it? Who is looking out for these things when they're going too far?
There's this concept of oftentimes the people are kind of a check for our government. If the people do not respond to our democracy and our government in a favorable way, we know we need to change it, because without the people and the voice of the people, we are not able to function well as a democracy and elect those representatives that we see fit. So I think at the end of the day, the people are the check for this, because they need to support our representatives and our officials in order to have society function properly.
I agree. And also, if you look at in 1870, Wyoming became the first state to grant women's suffrage, and that was really controversial at the time. So if things kind of can catch on, then they can then that makes them good. But the people are kind of the ones that kind of are the check on the government through new policies. And if they don't work out, then the people can kind of be the ones to tell the government that.
Perfect timing. Good job. This is our opportunity to give you some feedback. I just will start out by congratulating you on a wonderful presentation. I thought that your opening remarks were very cohesive and really dealt with the issue at hand in an intelligent way. I appreciated how comfortable you all felt with the subject matter, and the examples that you pulled out of history and out of the law were appropriate. And I really appreciated your reference right off the bat to JFK, one of my heroes. So that's always a good thing in my book. So congratulations, you should be very proud of yourselves. Candida?
Okay. Hi, I think you did a really lovely job. Thank you. It was a great pleasure to listen to all of you. And I have to say, my favorite, I hope you'll give me permission to use this in the future. My favorite line of the whole thing was, "so as not to embarrass the future." I thought that was just exquisite. Thank you. You really did an exquisite job yourselves, and you certainly did not embarrass yourselves or your teacher. You did a great job. I really appreciated your breadth, bringing in Wyoming 1870, that women got the vote, and talking about equality is one of the issues that hasn't been addressed directly. Thank you. You did a really stunning job, and I'm very happy that you're going to be citizens who will know what they're doing when they go into a voting booth. And I hope that, I'm not sure what you'd like to do in your life, but I hope that for someone of you, it might be representing the rest of us, because we need people in government who know what they're doing and who know what it's supposed to be. And if you all choose to do that in any fashion, you've got a good foundation now, and I hope you've had a really good time and have been bit. I hope you got bit by the civic ed bug. So thank you. It's been a pleasure listening to you. Best of luck in the future.
Yeah, I enjoyed this, and the struggle is, you made me feel smart because I understood everything you were doing, where you were going, and why you were going there, and that's really important. You answered the question in a way that logically made sense. You made it clear with context clues as well as your process of why you were saying what you were saying. You weren't just citing English cases to sound smart. You had reason for it, and you gave that to me. So you made me feel smart because now I understand some English law that I had no idea what was going on before we had this conversation. So well done there. That's a win in and of itself. Trust me. I really enjoyed the conversation. You did a great job of linking your answers to historical authority or precedent. That's very important because I do care about your opinion. But when you can pull in and say, oh, by the way, these folks up here that we call Supreme Court justices agree with me, that just bolsters your opinion that much more. And you did a good job of bringing that into our Q&A. So wonderful job. Thank you very much.
Thank you so much.
Thank you all so much.